This is the Kitsap Sun Editorial Board interview with candidates for the Supreme Court. We'll ask each of you to give a personal statement and any introduction in about 2 minutes. And Cheryl, we'll let you begin.
Thank you. I'm Cheryl Gordon-McLeod. I'm running for the open seat on the Washington Supreme Court. I live in Kitsap County, and I was the only one of the 4 competitors who had never run a race before, and yet I finished first statewide out of the primary. So I think a fair question to ask is, how did that happen? I think that what most people are looking for in a judge or a justice of the Washington Supreme Court is someone who will be fair. Let me tell you a little bit about my track record. I've spent the last 25 years arguing in favor of constitutional rights in front of the Washington Supreme Court, the court that I'm running for, and the similar appellate courts like the Ninth Circuit Court of Appeals. I have taught appellate practice, and I have been on appellate committees of the Washington Supreme Court. I think that's the basis of experience and knowledge that it takes to be fair. I've also argued in favor of equal rights for all, regardless of race, regardless of sex, regardless of pregnancy, regardless of sexual orientation. And I think that shows a dedication to fairness to all. And importantly, I've argued in favor of access to justice for all, and I've donated thousands and thousands of hours to people who could not otherwise afford a lawyer, which is probably the vast majority of us at this point, fighting for their rights when they're caught up in the criminal justice system. I think each of those is part of a track record that shows that I've been dedicated to fairness for all, and I think that's a track record that indicates that I would be fair as a judge. I also think that I have the temperament that it takes to be a fair justice, and I'll talk more about that later.
Sounds good.
Well, I'm Richard Sanders. I'm also running for the open seat on the state Supreme Court. This is created by the pending retirement of Justice Tom Chambers, who's endorsed me, as has Justice Jim Johnson, former Justice Phil Talmadge, former Justice Charles E. Smith, also former Dean of the UW Law School. Been endorsed by the State Republican Party, the Libertarian Party, business groups like the AWB, property rights groups, the state realtors. I was given the Outstanding Award by the Citizens Alliance for Property Rights. And I think that those endorsements come in recognition of my service on the court for 15 years. I'm the only candidate in this race with prior judicial experience. There's 3 things about experience that I think that we should consider. Number 1 is experience is the best teacher. And whatever walk of life we're in, if we experience something, we'll probably do a better job the next time we experience something similar. So it's a learning experience. On the Supreme Court, it's sort of an institutional memory too, because over those 15 years, I heard over 1,700 cases, wrote over 600 opinions. So I remember about something about most of those cases, about what the issues were, what the arguments were, who were the winners, who were the losers, and why. And I think that helps for the next case, because that's some knowledge that I can build upon. Not only that, but the knowledge I acquired in 26 years of private practice. I had a very general practice, did all kinds of things, although in the last 10 years or so I emphasized land use cases, and I gave seminars to other lawyers in land use litigation. Finally, experience gives me a record. People of this state understand where I'm coming from because they know what I've done over those last 15 years. I defended people's right to their private property. I defended the workers' rights of the workplace. I defended the rights of business when it came to all sorts of different issues, taxation. I was strong on open government, the Public Disclosure Act. In this packet of information, there's lists of these cases that I decided in various areas that give people confidence that from what I did before, I'll probably do again. I'm proud of my record, and I hope that I have your support.
Elaborate real quickly on you said in your first point that giving a second chance at something means you can do a better job. What do you mean by that? Is there something that that voters would expect from you differently in a second term, or not a second term, but a second stint? on the court. Is there something that's changed in you over the past 2 years? A different kind of experience you have now than you had before?
No, I don't think so. But every time I hear a case or litigate a case or decide a case, I learn something about the legal issues in that case, and it brings me up to a higher plateau for the next case. I think that's true in practice. When I had my first case, I didn't know very much about what I was doing. When I got to the second similar case, and I could build on that, what I did. So experience as a teacher, no matter what you do.
I wanted to ask a question about constitutional rights, since both of you have mentioned that, both of you kind of are campaigning on that. In your opinion, in this state, what's the biggest maybe threat to constitutional rights? And if you can even cite a court case as an example of what we need to be watching for. So.
Well, I think that in the judiciary, there are many judges that will tell you that they give deference to the government, and every constitutional right that we as individual private citizens have is a right we have against something the government has done or might do. So I think deference to the government is a killer when it comes to constitutional rights. It's a killer when it comes to civil liberties. Judges should opt for a level playing field, decide every case on the facts and on the law, and not put their finger on the scale of justice on the government side. And that's what I saw when I was on the Supreme Court for 15 years, and that's what I fought against.
What do you see in our society right now? Are there any issues? There are issues developing, privacy, healthcare, all of these sorts of things that people are talking about, constitutional rights. What's one that, that personally you see out there?
Well, there's all kinds of constitutional rights. You know, Cheryl has dedicated her practice to the criminal law, criminal defense. It's about a third of our cases. The other 2/3 of our cases concern all kinds of other things. For example, an initiative and referendum is a constitutional right we here in the state of Washington have under our state constitution. I remember early on, when I was on the state Supreme Court, the legislature went into special session to pass a tax for the Mariners Stadium, claiming that it was exempt from referendum by putting a little tag at the end of the bill saying it's immediately necessary to preserve the public peace, health, or safety. That ultimately went to the Washington State Supreme Court. I took the position that that is a question of law for the court to decide. A majority of the court said, however, they were going to defer to the legislative declaration, that this was a public emergency. A baseball stadium is a public emergency exempt from referendum. I thought that was an outrageous decision. I wrote the dissenting opinion. And you know, there's many different examples I could give you.
I do have a track record of fighting for constitutional rights, all of them, from First Amendment right of access to the courts for the public and the press and winning landmark cases establishing that right, to 14th Amendment due process rights, overturning even a death penalty case where we were able to prove that the state had actually hidden evidence for 15 years while the guy was on death row that was helpful to him. I guess I would say that the biggest threat to constitutional rights is the fact that there's so many people who can't afford a lawyer when they're caught up in the judicial system. And I say that because of my roots in the public defender's office in the 80s, my track record of taking on appointed cases since then, and my track record of doing pro bono or volunteer work, mainly at the Washington Supreme Court, Ninth Circuit, and Court of Appeals level, in all sorts of constitutional rights cases from the First through the 14th Amendment. But I think this question of access to justice is critical. I think it's what's keeping, I think the problem of public defender caseloads being too high, I think the problem of people not being able to afford a lawyer when they're caught up in the justice system, all threatens our rights to privacy and all of our other constitutional rights. So I think that the Supreme Court has a big role to play in terms of the administration of justice and affording access to justice, not just by the cases that it decides, but by the work it does on the administrative side. For example, increasing the use of technology so we can try and save some money and pour it back into the system. Committees on race and gender and the justice system, so we can assure that everybody is getting the representation that they deserve.
You made a comment when you were in your opening, and you said you were talking about equal rights, and you said different categories of people or demographics, and one of the ones you mentioned was pregnancy. There's obviously a political tinge to that because of what has gone on at the federal level as far as healthcare acts and things like that. How appropriate is it for justices to, or for judges, excuse me, to share their personal views and how you do this? And I'm going to ask the same question for Richard, because I know you've been fairly outspoken about some of the things you people do. So I just ask, in your opinion, how appropriate is it for you to share personal political views?
Well, judges and justices retain their First Amendment rights when they're candidates and when they're judges or justices. On the other hand, judges have to be fair and have to have an appearance of fairness so that there's confidence in the system. And I think that if judges take a stand where they are judging, prejudging, or appearing to prejudge an issue that's going to come before them, first of all, it's stupid because they haven't read the briefing and they don't know the facts. And second of all, it's unfair, and it reduces all kinds of respect for the justice system. You've said that pregnancy is tinged with political notions. I'm not sure that that's true. I have a track record of fighting for individual rights and constitutional rights. I'm proud of the track record, and I think it's fair game for me to talk about. One of the first volunteer cases I took on out of law school was to do a friend of the court brief in the United States Supreme Court in support of a pregnancy disability leave law. And I partnered with a number of unions and with Planned Parenthood at that time to write the brief supporting workers' right to disability leave for pregnancy, just as it was guaranteed for every other disability. And we won. I don't think that's ideological. I don't think that's political. I think that's a stand in favor of an individual right, and I think it's fair game for me to talk about.
Yeah, of course that's slightly different than what I'm getting at, is the things that get the headlines sometimes. Richard, you can criticize it for that in the past, but what's your...
I think that that we have to be realistic, and we have to realize that judges are human beings, and the judges have their own views about everything in life, just like anybody else does. And we have to be aware of that, particularly when we're a judge, because we have to set aside our personal preferences and try to follow the law, and that's what it's all about. So I remember when the hearings for the U.S. Supreme Court, when Clarence Thomas was asked a number of questions by the senators, and he was asked what he thought about Roe versus Wade. And Clarence Thomas said he didn't think about Roe versus Wade, and he hadn't read Roe versus Wade. And I thought, my first reaction is he's lying. And my second reaction was, if he's telling the truth, that's even worse. Because every alert individual, citizen that's interested in the law looks at these different cases and has some sort of a off the top of the head sort of impression about the way it goes. And this is human nature. So we shouldn't expect judges to abandon their humanity, but what we should expect judges to do is to follow the law. And I know that if I see a legislative act which I think is inappropriate or stupid, that doesn't mean it's unconstitutional, and I would follow it. If it's not unconstitutional, I would follow the text. So there you have it.
Can I follow up?
Yeah.
David? Go ahead. The Code of Judicial Conduct seems, at least the way I read it, to at some level temper your First Amendment rights, or at least try to cajole you into restraining them yourself. What's your view of the interplay between your First Amendment right to free speech and your obligations under the Code of Judicial Conduct?
I think you're correct. the code has been watered down a little bit in recent years, but it used to be that a judge could never pronounce his or her personal position on a controversial political issue, something like that. So yes, I think judges try to avoid that, but it's not a matter of substance, it's a matter of form. What's important about a judge is what do they think. It's not what they say. As Cheryl was saying, you don't want to talk about how you would rule on a case before you get the case. But the reason you don't want to do that is it would be, as she said, it's stupid to do that because you don't know. You haven't read the briefs, you haven't heard the argument. You can't really come to a legal decision until and unless you've heard both sides, you've heard all the argument. So I think that's the important thing.
I don't think the Code of Judicial Conduct is less a matter of substance and more a matter of form. I do think that there's some limits on what judges should be saying, and I think the decision in Washington, in Richard Sanders' case, that upheld the First Amendment right of a judge or a justice to speak his or her mind freely, left open a very important question. And the question it left open was, yes, the judge or justice can speak her mind, but what happens if a case on that issue comes before the court? And I think the unspoken answer is that judge would have to recuse themselves. So, although I think there's a retention of First Amendment rights, I do think the Code of Judicial Conduct wisely tells judges that they're supposed to be fair and appear fair, and it compels a judge to recuse themselves if they've prejudged or spoken out on a case. So that's where I think the interplay is, and I think it's substantive. I mean, particularly in a state like ours where judges are elected and where independence of the judiciary is so critical. I think that you want people who observe a code of judicial conduct and who are willing to be fair to all, regardless of race, creed, color, sexual orientation, and appear fair to all, regardless of those things.
Well, just to correct the record here, in my case, the one I think Cheryl's referring to, the court held unanimously that I did not violate the Code of Judicial Conduct, period. It wasn't a constitutional matter.
Well,
I don't think I muddied the record. I said that the court recognized that there was a right to the speech that you gave, but the court did not answer the unspoken question, which is what happens if an issue like that comes before the court? What would be the role of the justice who has previously spoken out on it? And I think the role would be to recuse.
Well, I think that Cheryl's talking generalities. That's not my case. I thanked my supporters for supporting me. That's not an issue that you recuse about.
What is the case you're talking about?
I think that Cheryl's talking about when I talked to a March for Life rally, or shortly after my swearing-in ceremony in January of 1996. I gave a 1-minute talk. I said thank you. They had endorsed me. I said thank you very much for your support. And because of that, the Judicial Conduct Commission went after me for 3 years. The ACLU defended me, a group that Cheryl's a member of. I thanked them for it. We won the case, and the state had to pay their attorney fees. So I have no apology for thanking my supporters, whoever they might be, and there's a wide variety of people out there that deserve to have their rights protected.
Speaking of endorsements, there's at least one group, the Seattle Metropolitan's election, who, rather than qualified, well qualified, or one of the others, they chose hostile to your campaign. Why do they do that? What's your response?
What group is this?
The Seattle Metropolitan's Election Commission.
CMEC.
I did an interview with them.
that.
They didn't invite me to interview with them. I have no idea what they're doing.
I had never seen that one before, so I wanted to give you any chance to.
I have no idea what they're doing. They didn't ask me, they didn't interview me. I really hardly even know who they are.
CMEC is one of the oldest organizations evaluating candidates on sexual orientation issues, and I recently interviewed with them a week ago, and I look forward to their decision.
Were you invited for an interview?
No.
That's. You have questions?
Not tonight, not right now.
Okay.
Surprisingly.
Mr. Sanders, have your views on same-sex marriage changed since your 2006 opinion on the Washington Defense of Marriage Act?
The Constitution has not changed since 2006.
Have your views changed?
Have my views changed? No, my views haven't changed.
So you still believe that the state has a compelling interest in upholding the institution of marriage?
No, my view in 2006 was the Defense of Marriage Act was not unconstitutional. It did not violate the State Privileges and Immunities Clause. My view in 2006 was this is a matter for the legislature. Since 2006, the legislature has acted. So it's a completely different ballgame now. It doesn't matter what my personal views are. I'm talking about what the Constitution
No, I'm talking about
requires.
your opinion with Justice Johnson. You went out of your way to say that the state had a compelling interest in upholding the institution of marriage. And I'm wondering if that view that you had then is a view that you continue to hold.
Well, I didn't write an opinion. I did sign Justice Johnson's opinion. I can't recall exactly how that phrase came up and what context it was. It was my opinion then. It is my opinion now that this is a matter for the state legislature.
Well, I actually think it's a matter that might well come before the court again, just as it came before the court in the Ninth Circuit following the vote in California. We have something on the ballot right now. There's going to be a vote on it. There's certainly a possibility that litigation might ensue. So I don't think it's a done deal in terms of whether or not that would ever come in front of the Washington Supreme Court again. I think the issue might.
And what's your personal view?
My view is that it might come before the Washington Supreme Court. So it fits into that category of cases where I'm not prejudging one way or the other. Whatever issues come before the court, however, whatever constitutional or non-constitutional issues are raised about it, I do have a view on the concurrence that Richard Sanders signed of Justice Johnson. And it's not a view about the legality, because reasonable minds might differ on a lot of legal issues, but it's a view about the factual, the supposedly factual things that were put into that concurrence. And they put in supposed facts about the children of gay couples being at higher risk, and the children of traditional male-female marriages being the ones who were bound to be at less risk. And they put in supposed facts about gay and lesbian couples being supposedly more promiscuous than male-female couples. I think those are factual inaccuracies that I could speak about, even though I won't prejudge any of the legal issues that might come in front of the court.
Well, when you're viewing or reviewing the constitutionality of a state statute, under the standard of review, you attempt to hypothesize. I mean, this is the standard review. You hypothesize any set of facts that the legislature could have believed that would constitutionally justify the statute. That's the standard of review. I don't particularly like that standard of review, but that is the standard of review.
Oh, were there facts being used?
There were legislative hearings, There were all kinds of facts that were offered into the record, all sorts of studies, all sorts of opinions, went one way, went another way, and when you're determining the constitutionality of the statute, on that standard of review, you assume that the legislature can believe any set of facts which would sustain the constitutionality of the statute. That's a standard of review.
And there's not the opportunity to throw out facts that may.
No, the court cannot. The court does not make factual findings in that kind of a situation. What they're doing is trying to determine if there's any set of facts that would constitutionally justify what the legislature did, whether those facts are real or hypothetical, and whether they're true or not. I know Cheryl has an opinion here, but I don't think that's the prerogative of the court to determine whether those facts are accurate or not in that context.
The question of you.
Go ahead, coordinate.
Both of you say you stand up for individual rights, some more stridently than others. What are your opinions on citizens' rights, but not necessarily against the legislature's actions, but against state agencies who put out their own rules or interpret the legislature's will, particularly on land use, which you have done, the Growth Management Act, takings, for instance. I use that as an example. Where do you stand on citizen versus the non-elected officials in the state government and their rules and regulations?
Well, I think the property rights cases are some of the most complex cases that come before the appellate courts, Washington Supreme Court, Ninth Circuit, and U.S. Supreme Court. And I think they do pit individual rights in some respects against the constitutional power of eminent domain and condemnation, and they implicate the right to just compensation for any takings that there are. I also think they're incredibly complex because, as you said, there's usually legislation, there's usually agency rulemaking as a delegation from the legislative body, and there's a question about, was it within the sphere of the legislation or was it outside the sphere of the legislation? And then there's the question of the individual and whether they're entitled to just compensation or whether they can stop the agency action completely. So it's difficult to comment in general without a particular case in mind, but I do think that those are some of the most difficult and complex areas of litigation because of the many levels of constitutional issues that there could be: constitutional delegation of powers issues, constitutional rights of the individual, constitutional right of the state to use its power of eminent domain.
But do you consider the agency's rules as carrying the weight of the legislature behind it, or do you have a different set of criteria for basing your decision on a private citizen's lawsuit?
Well, the question with agency rules is whether they're within the sphere of what the legislature passed. So no, I don't consider them to be on equal footing. They have to be measured against what the legislature permitted. And there's also a question about whether the legislature can delegate as much as they've delegated to certain agencies. So the courts do review them differently than legislation. They measure them not just against the Constitution as we measure legislation, but also against the enacting legislation.
Well, I think Cheryl's correct. When we're talking about an agency rule, we have to first determine whether the agency rule is within the scope of the statute. Is the rule authorized by the statute? Next, we have to determine whether the rule is consistent with the statute. Then we have to determine whether if so, does that deprive the citizen of their property with without due process of law, or take their property without just compensation. I remember one case we had called the six-pack well case, Campbell and Gwynn versus Department of Ecology. The state statute said that wells that pump less than 5,000 gallons a day are categorically exempt from the licensing process. So some developers in Kitsap County would drill a number of wells, 6 wells, so that they could have water for their development. Literally, it was within the exemption of the statute. The Department of Ecology, however, said that it was nevertheless subject to licensing. State Supreme Court, 5-4, held that it was subject to licensing. I wrote the dissenting opinion. I said, look, the state statute says that a well that pumps less than 5,000 gallons a day is categorically exempt. But most of my colleagues on the court took a different approach to this, and they said, well, look, let's give the deference, let's give the break to the government. I never believed that that was appropriate. First thing we do is look at the text, and if it doesn't pass muster under the text of the statute, it's unlawful. And I think that was an unlawful deprivation of these people's rights to drill wells without a license.
I'm curious, what's the most significant case that you've, what decision in your past do you think has had the broadest reach as far as this question of rights goes? Or maybe the one you're most proud of on how it's.
There's been a lot of cases. Maybe I'd go back to that initiative or the referendum case on the Mariners Stadium. The Mariners were threatening to leave town unless they had a new stadium. The King County Council passed a special tax to build a new stadium. That was subject to a referendum in King County. It was thrown out. The interest that be prevailed upon the legislature to call a special session of the state legislature, where they passed a Mariners Stadium tax as a public emergency. The same citizens that contested the validity of that tax before King County wanted to subject that to a referendum statewide. And the court said that they were going to defer to the legislature's declaration that this was immediately necessary to preserve the public peace, health, or safety, even though that is really a question for the court to decide, not to give deference to the legislature. So they did a great deal of damage to undermine the citizens' right to subject legislation to a referendum, which is a constitutional right guaranteed by our state constitution, and they built on that in cases afterwards. So I think that's a significant case.
Looking at the next level up, the U.S. Supreme Court, which justice do you, did I interrupt the second question?
I think I see where you're going, but I wanted to give Cheryl the same
it's totally up
opportunity.
to you. I can brag about a case
I'm sorry,
also.
What's that?
I can brag about a case also, but is that what you want to do?
Yeah. And I guess you're right, I am letting you brag, but I also, I'm trying to get some sense of what a decision that you think is very broad and affects the most people.
Well, I think I'm going to talk about the decision in Pete Cott's case. I represented the former Speaker of the House of the Alaska State House of Representatives, who was charged with some political corruption crimes by the federal government. And he was charged by the same set of federal prosecutors who charged Stevens, former Senator Stevens. And as it turned out, as we all know, there was a lot of exculpatory evidence that the government hid from Senator Stevens that wasn't disclosed until after he was convicted. As it turned out, those same prosecutors withheld the same type of evidence from this lower level politician, the former Speaker of the House. And when the whistleblower started letting people know that there was some hidden evidence in the Stevens case, we said, maybe there's some hidden evidence in this case. And even though we were already on appeal and already in the Ninth Circuit, we achieved a ruling that said we can go back to the trial court, that the government had to give us what they had hidden. We got 4,500 pages of hidden documents that were helpful to my client, that showed that the government's main witness against him, who was actually the same main witness against Stevens, had his own problems and his own reasons for lying, because he had his own exposure to some terrible child sex crimes. And we got that evidence, and we brought it to the court that convicted him, and then we brought it back up to the Ninth Circuit, and we finally achieved a ruling reversing all of Pete Cott's political corruption convictions. And I think it has a ton of impact because it stopped the government from overstepping its bounds. It has precedential impact in terms of teaching the government that it needs to disclose evidence that is helpful to the defense, and it can't abuse its power. And I also raise it because my client was a Republican. I don't care if it's a Republican or a Democrat, a black or a white, a man or a woman whose rights are being trampled by the government. The point is that we have constitutional rights, and I've spent a career protecting them. And I would like to be a justice on the Supreme Court to do the same thing for everybody, regardless of ideology, race, color, or creed.
And I think both of you, or I know you had brought up earlier, the whole element of cost for the individual person. And what can be done about that?
Well, these are tough times, and
even before, I mean,
yeah.
it's always been that to fight in court, to hire a lawyer, to go the whole route, it costs money. And if you win, that's all well and good. You might come out a little not as bad. But if you lose, I mean, that's someone's whole life in some cases.
That's I'm sorry.
No, that's kind of, I mean, it's to both of you. It's just a real issue that's always really bothered me.
Well, I think the Supreme Court, in its administrative role, has passed some rules recently that speak directly to that, and I think they're positive steps. They recently passed a rule limiting public defender caseloads. Now that's important because we had situations like the lawsuit out of Grant County where the ones appointed to take the public defender lawsuits were taking other cases on the side and not putting their time into the ones that they were getting paid by the government on, and basically throwing people under the bus. So I think the step, probably 25 years in the making, of limiting caseloads for people who are taking public defense contracts to something that's really manageable goes a long way towards ensuring that people who are caught up in the criminal justice system and who need a public defender are going to get one who has enough time to devote to their case. There was another rule in the works on the civil side allowing non-lawyers to help people in certain areas in an area that only lawyers could do before. Now, I know that this is an attempt to help people out who can't afford a lawyer, but I have a lot of misgivings about that rule because we can't even police our own lawyers to make sure they're giving effective assistance. I think it's harder if you have non-lawyers doing it. But it's a step in the court's attention to the fact that there's a ton of people out there who can't afford a lawyer when they're caught up in the justice system.
Well, the rule that Cheryl praises is the rule that I introduced and fought for when I was on the state Supreme Court. There was a lot of opposition. basically from municipal government, from counties, from prosecutors, because they said, well, this is going to cost too much money. And my attitude was, I don't care how much money it costs. The first priority we should have is protecting constitutional rights of our fellow citizens. And indigent criminal defendants, of course, have a constitutional right to defense at public expense if they're indigent. So the rule as proposed imposed maximum caseloads on public defenders, minimum qualifications and experience. There are other aspects to it as well that ensured a higher quality representation for indigent criminal defendants. And in different counties around the state worked in different ways. And Cheryl's entirely correct that there was a $3 million malpractice verdict against Grant County, and there was a malpractice verdict also for $3 million against another Eastern Washington county. There were pending lawsuits against a couple of cities here in Western Washington because local government wants to balance their budget on the backs of the indigent criminal defendants. And now we're hearing discussion in King County about spending more money on a public basketball arena. You know, and it seems to me that government has plenty of money. What they need to do is have priorities. And the number one priority is the judicial system. That is a core function of government, and important within that is the protection of individuals' constitutional rights. One other thing that I did, you know, the Code of Judicial Conduct provides that judges may propose things that will improve the law. So I got together a number of years ago, probably 10 years ago, with the Liberal Democrat Senator Adam Klein, Conservative Republican Senator Pam Roach, and encouraged them to propose a bill to the Washington State Legislature that would protect the constitutional rights of Washingtonians, which is to say, if the government violates your state constitutional rights and you prevail, the government has to pay you reasonable attorney fees. Now, unfortunately, that didn't make it through because in the budget committee they said, well, this is going to cost too much money. We have to pay for people to protect their constitutional rights. Of course, my attitude was, hey, it's not going to cost you anything if you stop violating people's rights. That's the mentality, and that's what I tried to fight against when I was there.
Does the and I just want to briefly touch on this because I know it became a real political thing 2 years ago with the disproportionate sentencing. Is the question of public defense and not enough money going to that, does that play a part in the kind of disparity in races who end up incarcerated in this state?
Well, I think that prosecutors make the initial determination of who's going to be charged. And they charge a disproportionate number of African Americans. And then it gets into the judicial system. And, you know, I think that an inadequate public defense is an inadequate public defense no matter whether you're black or white or red or green. And I think that the judicial system does the best it can with the resources that it has. I'd like to see it have more resources.
Did you want to comment at all on that?
Well, I do. I wanted to point out that in its administrative role, the Washington Supreme Court, around 2 years ago, shortly after the comments that Richard made during the last election, kind of reinvigorated its race in the Judicial System Committee and produced a report about 6 months ago that went through, that did some research for several years and went through the disparities in the racial disparities from the beginning to the end of the criminal justice route. The racial disparities between minorities and whites in who is stopped, once stopped, who is charged, once charged, who is diverted from the criminal justice system, once in the criminal justice system, how they're charged, once convicted, how they're sentenced. And the findings were disappointing. The findings were that race is involved at every step along the way, and that minorities suffer at every step along the way compared to whites. I think there's a great role for the justice system to play in addressing those disparities, and that report came up with about scores of suggestions for prosecutors, police, and the justice system that I think all need to be paid attention to. I do think the justice system does its best once cases are there, but I also think that there's some things that we all need to learn that could help us. And those recommendations really need to be paid attention to, because the disparities aren't just going to go away by saying that the criminal justice system does a pretty good job.
I'm going to change my previous question. There seems to be a lot of debate on the public's right to access information, going anywhere from PAC fund donors to sealed court documents. Where do each one of you come down on the right of individuals, newspapers, whatever, to be able to access government or judicial information?
Well, I certainly come down on the side of the First Amendment and the Washington Constitution's analog to the First Amendment, which protect the right of the press and the public to government information. I had one of the leading cases in about 2005 in which a judge closed the courtroom to the press and to the public for a portion of the trial, and the Washington Supreme Court agreed with the position that I advanced, which was you can't do that, at least not without a really compelling interest, like somebody's life is going to be at stake if this little portion of the trial is public. So I certainly am in favor of disclosure. I think the Supreme Court, again, in its administrative role, decided that even though the Public Disclosure Act doesn't compel the Supreme Court, like other government agencies, to disclose files, the Supreme Court itself was going to adopt a rule that allowed access to those same sort of files. I think transparency and openness in government is critical.
What's your opinion on important civil litigation or settlements with the courts sealing their records as part of the agreement?
On whether the courts should have the right to seal settlements in particular cases?
What's your opinion on that?
I'd have to have the particular case in front of me. I think in general the courts have been not doing that in the last 10 years since the litigation over openness in the courts has been pursued with more vigor.
On that question, I think that the Supreme Court has decided cases that have criteria that have to be used by the trial court in order to seal a file, and they've been enforcing those strictly over the last few years. So it used to be, for example, you get into a civil litigation with a multi-state corporation. They want to seal, or they want to settle the case, but they don't want to let anybody see what happened. So it'll be a precedent that can be used in the next case against the corporation. And that is a problematic practice that the Supreme Court has tried to limit and tried to make sure that those files are not unnecessarily sealed. You know, there may be some cases of personal privacy, but it's not that kind of case. The first part of your question, I think Cheryl answered in the context of the criminal law, but 2/3 of the cases we have are in the civil litigation. And the most important thing we do in terms of open government is construe and apply the Public Records Act. And in my packet, I have a page of a list of cases, 2 sides, of every one of these Public Record Act cases where I did all I could to vindicate the rights of the requesting party, whether it be a private citizen or a newspaper or what have you, to receive documents that are truly public that the government was trying to hide unlawfully, and then assess under the statute appropriate penalties and reasonable attorney fees. So I had the best record, in my opinion, on the Supreme Court during my 15 years on those issues than any other justice.
That's what I was going to ask.
That's what you were going to ask for.
Thank you. We're actually just about done here, so why don't we, is anyone, Ron, John, questions? I'll say thanks first for coming in and spending an hour with us, and then I'd like to give each of you 2 minutes to anything you'd like to say in closing or something that we haven't touched on. This will be your chance to do so. So Cheryl, Rachel, do that.
Thank you. I guess I wanted to talk for a moment about endorsements since Richard started with that. I have gained hundreds of endorsements, and I'm not saying that just because of the numbers, because I started out as the underdog, and I don't think numbers necessarily count, but I have a diverse set of endorsements. On the one hand, I have endorsements from the State Democratic Party and the Democratic county organizations and legislative districts across the state. On the other hand, I have the endorsement of former Republican Governor Spellman, former U.S. Attorney Mike McKay, notable leader in the Republican Party. I certainly have endorsements from criminal defense lawyers. I spent my career doing criminal defense. I also have the endorsement of former U.S. Attorney Kate Flower. I have the endorsement of the King County Police Officers Guild, and I have the endorsement of the firefighters. I have endorsements from both sides of the spectrum. I have the endorsement from the Seattle Times on the one hand, and I have the endorsement from the Spokesman Review on the other hand. And I'd like to bring out that what both of them said in their endorsements of me was that I had the right temperament for the court. I don't have the court experience that Richard has. Pre-primary, he always went on to say that the second best experience to having actual Washington Supreme Court experience is having argument experience of 25 years before the Supreme Court, and that's what I have. I don't think people necessarily need somebody who's run and won or lost for this political position before. I think people deserve a judge who's going to be fair. I think people deserve a judge with extensive experience with constitutional rights, with extensive experience applying those constitutional rights equally to all, regardless of race, sex, sexual orientation, or the amount of money that they have. And I think people deserve a justice who will do that with the appropriate judicial temperament. I think I'm the only one who wraps up all of those qualities into one.
Well, Cheryl's experience has been a criminal defense lawyer, an appellate lawyer. She's done a good job. I've heard her make many arguments before the Washington State Supreme Court. That's about a third of our cases. What about the other 2/3 of the cases? Been on the court 15 years, dealt with every kind of case that you can imagine, and I think that experience is our best teacher. But let me conclude by talking about my first day on the Washington State Supreme Court, which I thought was sort of set up where I was going from then on. There was a young black man, who was convicted of stealing $300 from an espresso stand, armed with a finger in his pocket. And he was sentenced to life without possibility of parole. And I thought that was an unconstitutionally cruel punishment, unconstitutional under our state constitution. And I sat at that conference table and I heard my colleagues go around the table, affirm, 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 affirm. And then it came to me and I said reverse. And I said reverse because his constitutional rights were violated. That was an unconstitutionally cruel punishment, in my opinion. And frankly, I didn't care whether someone out in the population or citizens were angry at me for trying to stand up for this guy's rights. Certainly it was not, those kinds of cases are not going to engender popular support for the justice that stands up for the lone individual, the unpopular guy. But I did that, and from that day forward, I decided that's the way it's going to be, that I am going to stand up for the rights of the individual, no matter what context they come to the court in. And that's what I did over those 15 years. Every single case, over 1,700 cases, I stood up for the rights of the private citizen, whether they were popular or whether they were very unpopular. That's what judges do, and if I get back on the court, that's what I'm going to do again.
Well, thank you.
Thank you
both
very
for
much.
coming in.